Good morning. Employment law is probably one of the most fun areas of the law, in my opinion. Maybe I'm a little biased because I practice in it. But employees never fail to do something really stupid. And that's why I love my job. And today I want to have a little fun. Hopefully I won't offend you. I may tell some dirty stories and say some cuss words, but that is just a part of my job and what I'm here to do. So employment law 101. In 45 minutes, it's going to be impossible. If you take a look at one of the last slides in the PowerPoint that I have today, there's a number of laws on there that I'm not even going to get to. So this is a highly regulated area that you need to be aware of. Today I'm just going to focus on trying to help you issue spot in a few different legal areas that I'm going to cover. But just like I would never practice tax law because, well, for one, I don't like tax law. No offense to anyone here that practices that. But you're going to want to consult an employment lawyer if you do have a complex employment issue, just because it'll save your client time and money. One of the slides on here is going to be important websites that you should know about. The most helpful would be the EEOC's website and the Department of Labor's website. They have great reference guides on the various laws that they cover and can give you an answer to an employer's or an employee's question fairly quickly. So I recommend that you check out those websites anytime you have an employee or an employer come to you with a question. And like I said, employment laws and regulations, they keep on growing. It seems like every year there's a new law instituted for employment law, so just keep your eyes open for that. So first, the most basic concept in employment law is that Iowa is an at-will employment law state. So what does that mean? That means that absent a written agreement to the contrary, an employer can fire an employee for any reason, for any lawful reason, at any time with or without notice. I don't know how many calls I get a week saying, hey, I was fired because I missed work. Well, that's a reason. You know, if you skip out on work, then they're going to be able to fire you. Now, there's a number of laws that do limit an employer's ability to terminate an at-will employee, and we'll cover some of these laws today. For instance, you know, you cannot discriminate against an employee. You also have the common law claim of wrongful termination, which the Iowa Supreme Court has found that you cannot terminate an employee for a reason that's against public policy. For instance, if an employee reports child abuse, you wouldn't be able to fire them for that. Or if they're seeking workers' compensation benefits, you cannot terminate them for that. So anyways, there are instances where you might have an employee who's no longer an at-will employee, and there's three basic ways that can happen. In the public sector, you're going to have collective bargaining agreements which may have a just cause standard, and that means that you can only terminate an employee for just cause. Well, what does that mean? That could mean that they engaged in reckless conduct. But that's not going to allow an employer to just terminate an employee for any reason. So one of the things you're going to want to look at anytime you have an employer or an employer come to you and wants to terminate an employee is, one, are they at will, or do they maybe have more restrictions on them because they're covered by a collective bargaining agreement? Or likewise an employment agreement which may say that they can only be terminated for cause and then spell out what that for cause definition would be. Another thing is that handbooks and employment policies typically do not create a contractual relationship between an employee and employer, which means that they would be presumed to be at will. But those handbooks and employment policies need to have specific disclaimers that say, you know, this is not a contract. You are still an at-will employee, and those need to be all over the handbook. And every employer should have a handbook, no matter how small they are. All right, so the first laws that we're going to get into are non-discrimination laws, and this is my favorite area of the law. So I just want to show you a quick video from the office, or it's a bunch of clips put together, And this is what you're going to hope that your client has not faced, or that your client, if they're an employer, has not done to their employees or let take place in the workplace. Oh. Hold on. It's not coming up on the screen, so. Okay, you stay up here so that I can.
This is huge. That's what she said. Let's do it. Get up. Let's get real.
Okay. If I have to do this, based on stereotypes that are totally untrue, I do not agree with, you would maybe not be a very good driver.
Oh man, am I a woman?
So, I don't know if you like country music, but I was thinking maybe one of these days we could drive out to the field to crank up some tunes, smoke a few back into those, maybe even toss a disc around. But we can take me and okay.
Yeah, go try to just what? And I didn't tell anyone because I'm not really sure how I feel about it.
That's not true. Redact it. Redact it.
Well, I'm not actually making a formal complaint. I just really think we should talk about the line like this must be obvious. How long was this? Oh, the Antichrist. You can't. Oh, not push religion.
Oh, but I can push drugs in here. Is that what you're saying? Well, you have to pick one or the other. Your choice.
No, sweet cheeks. We need somebody who's actually made a sale.
Am I hot right now?
Why would I or anyone else think that you're hot right now?
I need 2 men on this. That's what she said. No time. What she did. No time. Guys.
I never touch a pregnant.
Yep. No. $300 to me.
How's that?
You know, gavel I
Squeeze in your bank. That's what she said.
Or you saw it like this.
Okay, really?
Would you consider this a terrorist incident?
I felt terrorized.
Come on.
Michael's got a few tricks for Valentine's Day. He found a place where you can get 12 plastic roses for $10, and he's got a great line. Me so thorny.
Hey, yeah. Oh, nah.
All right, so that's just a little something to brighten up the day and to let you know that employees should not be subject to that kind of behavior.
And there's a water cooler, and here's your desk. Thanks for showing me around. No problem. Hey, everybody, this is Ted
You
Bates.
might need
That's
to-
the accounting team. That's Chloe, Kelly, Jenna, Renee, and Steve. Hey, everybody. If anybody needs me, yell.
All right, so what is prohibited discrimination in Iowa? That is to make an employment decision based upon a protected class. So what types of employment decisions am I talking about? And we'll kind of take this definition in 3 different elements. First, employment decision. So hiring, firing, promotions, assignments, wage increases, all of those would be employment decisions that cannot be based upon a protected class. Then what's based upon? Based upon can be proven in the court of law in 2 different ways. One is with direct evidence. So you may have an employer or supervisor say, you know what, you're not getting this raise because you're a female, or you're not getting this raise because you're black. That would be direct evidence of discrimination. Another way to prove it is with indirect evidence, and that is by showing that other individuals who are similarly situated to yourself were treated differently. So if you have a female who is denied a pay raise, but all of her male cohorts were given another pay increase, then that would be evidence of discrimination. So what is a protected class? Well, I'm going to ask you to try to help me define what a protected class is. And this will vary by state. And Iowa is actually pretty progressive in what it, in who it protects. So can anyone tell me what classes they think are protected here in Iowa? And we saw some in the video of The Office. Yes? Race, okay. Gender, yep. Disability. How about those individuals who are senior, gray hair people? Age, yep. Religion, yep. Pregnancy is also a protected class. We have genetic information, which would be, for instance, if you learn someone's family history, family medical history, that's protected. You also have color and national origin, and then military status, and in Iowa you actually also have sexual orientation and gender identity. So a lot of times you may get an employee that calls you up and says, you know, I was treated unfairly. This is outrageous. This is ridiculous. I want to sue my employer. And you're going to say to them, well, not everything that's unfair is discrimination. So just as an example, I represented a suburb of Chicago a few years ago, and they had a black police officer who was having sex in his cop car with a teenage girl who he had met teaching there at the local high school. And so he was caught because the father found out of this teenage girl, and the father calls the city and says, hey, your police officer is having sex with my daughter in his cop car, on duty, by the way, so you should do something about it. So the police chief calls him in and asks him, you know, what's going on. They do what's called an interrogation in Illinois. And the police officer denies it at least 12 different times during this interrogation. So the city finds out that it is in fact true. He's having sex with this girl while on duty in his cop car multiple times. And so they terminate him. Well, he ends up suing the city for race discrimination. And because he thinks it's not fair that he got terminated. Well, needless to say, we won that case pretty easily because it was not discrimination because we terminated him. We had a legitimate reason for terminating him, and that was because he was having sex in his cop car multiple times while on duty and also lied about it. So one of the things you're going to want to find out when an employee calls you up and says, you know, this is outrageous, this is ridiculous, I was fired because of X, Y, and Z, you're going to want to know, well, hey, what's actually going on in the background? And figure out whether it's actually unfair or it's just discrimination, or, you know, the employer actually has a legitimate reason for terminating them. Another thing is that there are fair, non-discriminatory decisions that can be made. Just as an example, when hiring someone, if you're going to hire, let's say you have two candidates, a man and a female, and you're looking at their education and their experience and their training, and the male may have more education and more training and more experience than the female, so that would be a non-discriminatory reason to hire the male over the female. So those are key reasons to hire someone versus another individual. You can also look at seniority, like for example, if you're giving someone a promotion, if the female were to have more seniority than, let's say, a minority female, then that would be a reason to promote the white female over the non-white female. The next thing is harassment. Now this is a pretty hot topic issue right now. And it's often tagged along with discrimination claims when you see a discrimination charge filed. And basically, prohibited harassment is severe or pervasive conduct because of a protected class, which are those protected classes we talked about earlier, that is unwelcome and that affects employment, unreasonably interferes with work performance, or creates a hostile work environment. So not everything is going to be harassment because it has to be based upon a protected class. So a lot of times employees will get this wrong, that they think they're being harassed, but it's not. A perfect example of this is someone, let's say you have a coworker who works in your cubicle next to you, and let's say they have bad hygiene, they're always picking their nose, they're coughing, maybe farting. That's not harassment, even though it may meet all of those definitions, because it's not based upon a protected class. Here's just a good chart of what types of forms harassment can take. Physical, verbal, and visual and written are the three main categories. One important thing to highlight here is that ignoring and excluding an employee can constitute harassment, which most people may not typically think of. So that's something to keep in mind. The other thing, too, is that when you have a lawsuit, an employment lawsuit based on harassment, you're going to want documentation from the employee other than just their own words. So because that's going to come down to a he said, she said situation. So if it is visual and written, you're going to want to have that employee give you all of the stuff that they think is harassment, and you're going to want to look at that prior to filing any sort of lawsuit. And you're going to want to have individuals that would testify on behalf of the employee or on behalf of the employer if they think it's physical or verbal, because that stuff may not be written down. Sexual harassment can take two different forms. One is quid pro quo. So if I had our male law clerk come into my office and said, you know, I'm not going to promote you as someone in this firm unless you give me some sort of sexual favor, that would be sexual harassment. Likewise, if I said, you know what, if you don't do this sexual favor, then I'm going to ask that you be fired, that would be quid pro quo sexual harassment. And then you also have hostile work environment, which we just briefly mentioned. One important thing for sexual harassment with both of these forms is that employees must prove that the conduct was offensive to someone, not necessarily the victim. So the victim may be overly sensitive, so you're going to look at it from a reasonable person standard. Does someone actually think this is offensive? That's something you're going to have to look at if you have an employee come into your door or if you're dealing with an employer. Next is prohibited retaliation. So this is a little bit different because you're looking at a protected activity, not at a protected class. So this is when an employer takes negative action because of a protected activity that would dissuade that protected activity. And on the next slide I have there's three different categories of protected activity. The most common that I've seen is when you have an employee participate in an internal investigation, such as a sexual harassment investigation, which would be under participation, or if they are requesting their reasonable accommodation for disability or whatever else. So they're going to be protected once they engage in any of these protected activities. Now, the most important thing, though, with respect to retaliation is that there has to be some connection between the protected activity and the negative action. Usually, timing is a good indicator. So if you have someone who's, let's say they request a reasonable accommodation from their employer, and within a few days, then the employer takes some sort of discipline against the employee. That timing is usually is good evidence of retaliation, but it's not enough. There's got to be more evidence than just that. Another thing that typically happens if an employee knows that they're going to get in trouble, they will come into the disciplinary meeting if they know they're going to get in trouble, and they will say, oh, by the way, I just filed a discrimination charge with the EEOC, so now I'm protected, you can't discipline me. Well, that's not true because the employer pre-planned to discipline them during that meeting so that there couldn't be a connection between the protected activity and the negative action. All right, so the two laws that are going to protect against discrimination and retaliation and harassment are the two main laws is Title VII, the Civil Rights Act, as well as the Iowa Civil Rights Act. Now, Title VII applies to all employers with 15 or more employees, and it's enforced by the Equal Employment Opportunity Commissions. One of the most important questions you're going to want to ask yourself when you get an employment issue in the door is, one, does the law that the employee or employer is saying is violated, does that even apply to my client? So this applies to employers with 15 or more employees. The Iowa Civil Rights Act applies to employers who employ at least 4 persons. Now, the Iowa Civil Rights Act is more expansive than the Title VII because it protects many more classes. In particular, with respect to age discrimination, they protect individuals that are 18 years or older. As I'll discuss later, the Age Discrimination Act only protects individuals that are 40 years or older. All right, so procedurally, which is important for you to understand, is that in order to bring a lawsuit, a discrimination lawsuit that would fall under Title VII or the ICRA, would be to file a discrimination charge with the EEOC or the ICRC. In Iowa, if you're a plaintiff's attorney, and hopefully I'm not giving away any gems for you, you would typically want to file with the ICRC because they're more employee-friendly, and the EEOC typically doesn't even have time to complete an investigation. So what's going to happen once you file a discrimination charge with the EEOC or ICRC is that they're going to conduct an investigation. The ICRC has a screening process where they're going to have the employer submit a position statement, and after the employer submits a position statement, they're going to either screen in or screen out the employee's claims. Now, if the employee is making every claim they can possibly make, there may be some claims that are screened in and some that are screened out. Once claims are screened in, then you do interviews with employees and supervisors at the employer's job site. And at that point, the ICRC can make a finding of probable cause, which is bad, or it can issue a right to sue letter, which is all right because then the employee can go to a state court or federal court, or they can make a determination of no probable cause, which was very bad for the employee but good for the employer. One thing to know with respect to right to sue letters is that you can request a right to sue letter 60 days after you get a discrimination charge on file. So if you would rather go straight to federal court or state court than wait on the ICRC, you might as well get your right to sue letter. That may also help with leverage with settlement negotiations if you're in court where it becomes a public record versus with the ICRC. The other thing is that there's deadlines for filing a discrimination charge with the EEOC and the ICRC. And in Iowa, that's 300 days from the discriminatory act. So it's a very, very tight window. So if you get a call from an employee, you're going to want to act very quickly because you're not going to have a year or 2 years to sit on something before you file a discrimination charge. And you have to file that discrimination charge prior to filing a lawsuit. And so let's say that you get a right to sue letter from the ICRC. As soon as you get that right to sue letter, you have 90 days to file a lawsuit. So again, you don't want to be sitting on your hands. You got to move these things along fast to make sure your client's rights are protected. Damages and injunctive relief available under the Title VII and ICRC are basically back pay, front pay, reinstatement, punitive damages, compensatory damages, attorney's fees. One of the reasons that attorneys don't like to file in federal court under Title VII is because there is a statutory damage cap for compensatory damages where you don't have that in Iowa. So I think the cap is, it's based upon the employer's size, but it's around $300,000. So the next statute, does anyone have any questions about Title VII or the ICRC at all? Okay. Oh, okay.
Can a company give preferential treatment, raises to females for the purpose at least of greater equalization between the male and female employees?
I would say no. No. Or, well, hold on. Do you mean...
The employer thinks I've got it out of
okay.
Equalization.
Yep.
And so I'm not going to give raises to the men, but I'm going to give raises only to the women because they're women, because I want to get it more closely equated. And then if they do that, isn't it a admission that in the past they were not paying their women enough?
Yeah. Well, I mean, it would be an admission. You would just want to make sure you do it somewhat discreetly. And there would be a statute of limitations with that. But there is the Equal Pay Act, which I was going to talk about later, which requires you to pay men and women equally for the same type of work. So the best thing for you to do in that situation would be to raise the women's pay, because if you don't and they find out, they're going to file a lawsuit. So.
Yeah, I have a question with regard to the difference between filing under the ICRA or Title VII. Is there a situation such that you pick your poison? Which is a better way to go? I mean, if I elect to file one, am I precluded from filing under other? Or do I do both at the same time? What's your thoughts?
Well, actually, when you file with the ICRC, they cross-file it with the EEOC. So you're essentially protecting both avenues because they're cross-filed there. So you would want to do it. You would want to file with the ICRC, and I can't remember off the top of my head whether the EEOC, if they automatically cross-file with the ICRC, but that's something to consider. So you would be protected. So, any other questions on that? Okay. I'm going to move on to age discrimination in the Employment Act, and that again is enforced by the EEOC. So again, you would want to follow the same procedures, which would be filing a discrimination charge with the EEOC or with the Iowa Civil Rights Commission. That prohibits discrimination on the basis of age, and again, only for individuals 40 years or older. It applies to employers with 20 or more employees, which is different than Title VII, if you remember. And then there's exception for bona fide occupational qualifications. And just as an example of a bona fide occupational qualification is, this is why there's mandatory retirement ages for our judges who have to retire or at least go on senior status at age 72. It's also a reason why it's okay to have a mandatory retirement age for police officers and pilots and firefighters. So some age discrimination is okay if it qualifies under a bona fide occupational qualification. Next is the Americans with Disabilities Act, the ADA. This is again enforced by the EEOC, and it applies to employers with 15 or more employees, and it prohibits discrimination against a qualified individual with a disability. What the heck is that? That is an individual, one who has a disability. So what is a disability? A disability is something that impacts or impairs a major life task or ability. So for example, if someone has a condition that impacts their ability to walk, to work, to stand, to sit, that will most likely qualify as a disability. Examples include cancers, serious heart conditions, depression, so other psychological conditions would qualify as a disability. Now, even though you have a disability, so you're an individual with this disability, you have to be a qualified individual. That means that you have to be able to perform your work duties with or without a reasonable accommodation. So just as an example, I've had a case where we had an individual who had a very serious stroke. And he was unable to perform his job duties even with a reasonable accommodation. So even though we gave him a lot of unpaid time off, he was still unable to perform his job duties. So the employer terminated his employment. He then sued for disability discrimination. However, the court ruled that because he was not able to perform his job function with a reasonable accommodation, he was not protected by the ADA. Now, the ADA requires employers to make a reasonable accommodation for these types of individuals. That can range from buying someone a specific piece of equipment. It can be unpaid time off. There's a limit to that, but it can include that. It can also include a reassignment of job duties or structuring their work schedule differently. So let's say you have someone with a sleep disorder and they say they can't get into work till noon. Let's say that's a believable or that's a real disorder for that person. Then you'd have to structure their work schedule to allow them to come into work at noon. And I kind of already covered these first 2 points, but limitations to this is that an employer does not have to give an employee a reasonable accommodation if it's going to be an undue hardship on that employer. So that could be financially or otherwise. As an example, let's say you have a police department, and in Iowa you have a lot of cities that are very, very small. So let's say that there's a police department with only 4 officers in the city that even work. And you have someone with a disability who wants unpaid time off, and they're not going to be able to return to work for 3 months. Well, if that creates an undue burden on that city, that small city, because they're in a bind because now they only have 3 officers, they're all going to have to start working overtime, which is going to create a huge financial burden for the city. They may be able to get rid of that employee or say, you know what, we cannot provide you with the reasonable accommodation that you're requesting. So that's something to keep in mind. The other thing is that employer is not obligated to provide an employee with the exact accommodation they're requesting. So if they say, I want this new machine that is worth $1,500 to help me do my job duties, the employer can say no, because here's another machine that's only costs $50 that's going to help you do the same thing. So it's within the employer's discretion to kind of work with an accommodation that will actually work with the employee. Equal Pay Act, which I touched on briefly, requires employers to pay females and males the same as long as they're performing the same type of job duties. So now I'm going to get into wage and hour laws. The other thing to note, because I mentioned that one thing to look at is the size of the employer when an employment issue comes into your office, is to know is that employer actually covered by the law. The other thing to look at is whether there's a state law and or a federal law that covers, because in Iowa there's a lot of state laws that also cover the same issues as the federal law. So the first thing is the FLSA, and that's enforced by the Department of Labor. And again, the DOL's website has great reference guides for you as attorneys to look at if you ever face one of these issues. Now, the FLSA requires employers to pay minimum wage, which isn't news to us. It's $7.25, both under federal law and state law, and they also require overtime for employees who work 40 or more hours. Now, I've had clients call me up and say, you know, I pay a minimum wage, but I don't pay them overtime, but they never work on average more than 35 hours per week. So what they're trying to say is that they work, let's say they work 60 hours in 1 week, but only 20 hours or 30 hours in the week after. For that week 1, you still have to pay overtime for those 60 hours, because once they go over 40 hours, you have to pay overtime. Even if over a 2-week period it averages out to be less than 40 hours. Now, there's certain exceptions, for instance, in the healthcare field and also in law enforcement, but that is the general rule. And again, overtime is just time and a half. for those employees. It's kind of complicated with respect to who's covered by the FLSA. It's not as easy as saying, oh, it's anyone with over 20 employees. Instead, the DOL looks at how much money the employer is making per year, and as well as how many employees they have. So, first of all, any public agency that employs more than 2 employees is going to be covered by the FLSA. So schools, cities are going to be covered. Secondly, any private sector employer who hires at least or has at least 2 employees and has an annual gross income of $500,000 is going to be covered. And lastly, anyone that engages in interstate commerce is going to be covered by the FLSA. Now, what employees are covered? Essentially, blue-collared workers are covered, so you have plumbers, electricians, construction workers, and anyone who's making less than $23,660 a year. There's the exemptions. I'm not going to go into detail, but you should just know that there's exemptions. You also, in order to qualify for an exemption, you have to meet 3 tests. One is they're paid on a salary basis. They're not paid hourly. Second is they're paid at least, or I should say more than $23,660 a year. And then you look at their duties. One thing to know here is that the law is changing. The salary level in 2016 will be doubling, or at least it will most likely be doubling, to about $50,000, a little bit more than $50,000. So in order to qualify for a white-collar exemption, the salary level, they'll have to be at around $50,000. And then highly compensated employees are employees who make over $100,000 a year. There's other requirements as well, but that's the most basic requirement. That salary level is going to be moving up to $122,000 in 2016 as long as the proposed rule goes into place. You can get more information on that from the DOL's website. Again, there's a number of penalties if you violate that: attorney's fees, costs, liquidated damages, unpaid minimum wages, and then unpaid overtime. Statute of limitations here, since this is enforced by the DOL, you do not have to go to the ICRC or to the EEOC ahead of time. You're just going to be going straight to court. Statute of limitations is 2 years, 3 years for willful violations. Iowa wage and hour laws cover basically the same thing. You're going to want to look at the Iowa wage payment law if you want to know when employers should be paying their wages, what happens at termination, what can and cannot be deducted from wages, and stuff like that. So look at that law for information on that. Then there's several laws, and I'll go through this real quickly because it looks like we're about out of time, that mandate leave, and the first 2 are unique to Iowa. So Iowa has a Veterans Day leave law that requires employers to give veterans Veterans Day off. That does not mean it has to be paid. They just need it off. Same with jury duty. You have to allow an employee to be gone for jury duty. Again, that's within the discretion of the employer whether they want to pay it or not. A third law that's unique to Iowa that I forgot about that's not on this slide is voting leave. So you have to give employees paid time off to go vote. Now this is up to 3 consecutive hours of paid time off to vote in elections. The other unique law that most people don't know about is applies to nursing mothers, and this is because the Obamacare Act amended the FLSA to require employers to give nursing mothers reasonable break time to pump milk. So just to keep that in mind. And if they pay other employees for that break time, they have to pay the nursing mothers. I'm going to stop there because we're just about out of time and open it up to questions if anyone has any questions. I'm sorry, there's so many laws. I couldn't get to everything, but hopefully at least you have a good idea of what's in store for you. All right, well, I guess you can go to lunch then. Thank you.